Hello?
Mr. Brewer,
Yes.
this is Judge Marek. I'm here in Jackson County. I'm calling you first with regard to case State of Kansas versus Brian Brewer. It's 19 CR 26. I'm here in one of our courtrooms. Present on behalf of the state is Ms. Gerhardt, who's one of our assistant county attorneys. Here in maybe a few moments, we may talk about the civil case. We also have here, I believe Ms. McKnight is present here in the room and has someone else with her also. One of my clerks is in here with me. Because this is a proceeding of the district court and I'm the district judge, these proceedings are recorded. You may be interested in that. So a couple things I thought I might address and make clear. I did receive this, it hasn't been filed yet, but your request to appear by phone. And that's why you're calling, we're calling you. We'll talk about that in a moment. But one thing I want to make clear, I'd seen some of your other filings, but they weren't connected to a name as to mentioning an attorney of fact. And apparently that's Ms. McKnight. And although it's fine for her to have brought this piece of paper up here, because it's just something you want filed, the version we got of this request to appear by phone is just one page, but it doesn't have a signature such as your signature. I don't know if there was a second page, but
There was
at
not.
any rate, okay, so we have the whole document. But I do want to make clear that in terms of the court proceedings, even if Ms. McKnight's your power of attorney or whatever, she is not appearing here today as an attorney.
That's why I asked to appear by myself over phone.
Okay, and that's fine. I just want to make that clear because I don't want her to get into Dutch for practicing law without a license, and I'm not suggesting that, but I know that she's brought some paperwork on your behalf. And again, that's fine. There's nothing wrong with that. Okay, so in this criminal case, a couple things that we think are important, or I think that are important, just to make clear. One of the reasons for an appearance today, and I know you filed some stuff waiving certain things, if you will, but I'm going to treat this as your arraignment because I'm compelled to go over the charges with you so that you're aware of the charges, even if I understand you may have read them, and to discuss with you some of your rights so that we're clear on the record that you know what you might be waiving.
Can I ask a question?
Yes.
Why weren't these rights and everything protected under my other hearings?
I don't know what other hearings you're talking about. I haven't met you before, so I wasn't present at those
I'm sorry, I
hearings.
figured you'd read all my motions and everything. I go over all this, but
I have read all your motions and filings, but that doesn't necessarily give me a clear path of everything that's happened. But regardless,
I can go ahead and waive formal reading on the record if you'd like.
that's fine, but my practice is still to make sure and go over here, particularly someone who, and we'll address here in a moment, the nature of how you want to represent yourself. But I still think it's important that at present, I'm looking at a 3-count complaint that was filed. And so count 1 alleges that on December 17th, 2018, here in Jackson County, that you unlawfully, intentionally, knowingly, or recklessly possess marijuana. This is charged as a B misdemeanor. The maximum penalty would be 6 months county jail, $1,500 fine, and/or both. Count 2 alleges on that same date here in Jackson County what we would call possession of drug paraphernalia. This refers specifically to a pipe and some plastic containers that could be used to store, contain, conceal, ingest, or inhale a controlled substance. This also is a B misdemeanor, and the maximum penalty is the same as I've just mentioned. Now, count 3 alleges on that same date here in Jackson County that contrary to the statutes, you unlawfully, knowingly obstruct, resist, or oppose a person or persons you knew or know to be law enforcement officers. In this case, it says Deputy Hanukkah, and the officers were authorized to perform a official duty, and that you resisted or substantially hindered or increased the burden on Deputy Hanukkah. This is known as interference with a law enforcement officer. It's an A misdemeanor. The maximum penalty, year in the county jail, $2,500 fine, and/or both. So with regard to these particular charges, you have several rights. Because they do have the potential for jail time, you are entitled to have an attorney appointed to represent you in the matter if you cannot afford to do so. You have the right to ultimately a trial by jury where the state would have to prove beyond a reasonable doubt that you've committed these crimes. At that trial, you'd have the right to call witnesses, cross-examine witnesses, and you could testify in your own defense, although you could not be compelled to do so. If there are rulings of the court in the matter, you can appeal those to the Kansas Court of Appeals. Based on what I've already read in your file, the court's going to note a not guilty plea on your behalf at this time. Also, in looking at your filings, it appears that you desire to represent yourself. Is that still the case, sir?
Yes.
All right. And this may be a little bit redundant because I know you have some background in dealings with the courts or such, but you understand that while you have a right to represent yourself, you're still going to be held to certain standards. In other words, just as if we were in a trial, if there's an objection from the other side, because you don't ask a question in a correct way, I'm not going to be more lenient to you just because you're not an attorney. I mention that just because sometimes there can be some obstacles and some difficulties in accomplishing a person's goals. For instance, your goal may be to present certain evidence and to get that admitted. Also, I'll point out it's a little bit difficult to, for instance, if you decided in a trial to testify in your own defense, it's a lot harder to do that than to have an attorney who can then take you through some questions while you're on the stand under oath. Now, again, it's not that it can't be done. My purpose in pointing these things out is just to make clear to you that by waiving your right to be represented by an attorney, there can be these difficulties, and that the court's not going to treat you differently in terms of the presentation and such that would happen at that. Now, one of the other options that is done in some cases is for you to have a standby attorney, I'll call it, who would be appointed to provide you with some advice and guidance, but you would still be doing, the questioning, cross-examination, those type of things. Have you considered that as an option?
Well, I did read the or a booklet, I guess. It's 200 and some pages put out by the Federal Judicial Center on pro se litigation, published in 2016. I don't know if you're know anything about it or anything, but it's an extremely good, effective tool. And I think that might be a good way to approach these proceedings, but as I understand the Kansas statutes, as a defendant, should I not request discovery, I don't have to get any of my evidence approved or anything. I just go with it, correct? Because most of my evidence is going to be the county of Jackson, the courts, my lawyer, everybody against me in order to get these charges put on me. And that's where we come to the change of venue.
Yeah. Well, we can talk about that in a moment here. Again, though,
I'm waiving the side counsel.
Okay. I just want to make that clear. And maybe we can touch on this. You mentioned something, just because you're representing yourself at a trial doesn't mean that any evidence you wish to present that the jury would hear.
So I don't have the right to remain silent until I present my defense?
Oh, absolutely. You have the right to remain silent. But in presenting your defense, you may choose to, let's say you want to call a certain witness. There may be an objection to the relevancy of that witness. And then the court would need to rule on that.
Right, but also, anything in my possession, the court wouldn't have to rule on.
Actually, that's not the case. I'll give you an example. We just tried a case last week to a jury. In that case, the gentleman was represented by an attorney, but did desire to give his own closing statement. In support of his closing statement, he offered certain documents that he wanted admitted into evidence. Those documents consisted of the United States Constitution, the original territorial law of the state of Kansas, and I think the Bill of Rights. Those documents were not admitted into evidence.
Because they weren't admitted at his trial.
No, before he made the decision to give a closing, while he was still in his case in chief, he offered those documents because they were part of his decision-making process of whether he was going to give his own closing or not. At any rate, those documents were not admitted by the court because they're not admissible in that jury trial. Now, that didn't mean that in closing statement he couldn't refer to the Constitution. He certainly could. He could refer to in closing, because closing is not evidence. He certainly could mention those, but they were not admitted as exhibits. And so my point is, just because you have a piece of paper that you want admitted as evidence doesn't mean that it will be admitted. It's a ruling from the court.
Now, we're talking about the civil case here, which is for body cam footage, which they obviously...
Now, okay,
you don't want
Mr. Brewer, I'm not going to talk to you about the civil case right now.
Okay.
We're only going to talk about the criminal case. Once we get done talking about the criminal case, then yes, we will talk about the civil case.
Okay.
And do some scheduling for that. But let's stay focused on the criminal case. So I'm going to note that you're going to represent yourself, and we've discussed, at least in general outline, the goods and bads about doing that. Okay. So there are, in the file, of this criminal case, various motions that you filed. And we can certainly discuss them. Some of them we may be able to see if we can give you a ruling on or not today. Others, I think, are going to have to be briefed because the state's probably going to want an opportunity to look at those. But before we address that, there's another key issue here that's unique to Kansas and somewhat unique to our judicial district. And I just want to make sure that you are treated the same as everyone and that you make an informed decision about this. Because our magistrate judges are not attorneys, that means that where we have a misdemeanor case, you have the opportunity to have a bench trial to the magistrate, and if you were convicted, you could appeal and have a jury trial at that time. And generally, that's why most of our folks meet the magistrates first, because most of our misdemeanor trials are tried to the magistrate first, and then the person decides if they want to appeal and ask for a jury trial. Now, it is true that they can skip that step. We call it two bites at the apple. So a lot of times litigants who are represented by an attorney will go ahead and try a case to the magistrate because it's sort of it's almost a freebie. You can learn things in that case that you might not have learned otherwise, because you get to try it once, you get to call witnesses, you can cross-examine them, you can, etc. You can get all that information. And then, of course, if a person's acquitted at a bench trial, they're done. But if they're convicted, they still have that right for a jury trial. Again, a person can say, I just want to go straight to a jury trial and skip that first step. So is that clear to you, what I'm explaining?
Yes, it's clear to me, and I'd rather just go to the jury.
Okay. That's fine. And I'm going to note that, and you had made a written request, but I wanted to make sure that you understood the two-layer process. There's a number of counties here in Kansas where that differs because some of the magistrates, about half of them are law trained. And so that can change that, if you will, two bites at the apple routine. But because all of the magistrates in the Second Judicial District are lay magistrates, we uniformly kind of go through this particular procedure on misdemeanor cases. Obviously, felonies, we don't do that on. So this would be tried to a six-person jury then if we go down that road. So that kind of takes care of some of the preliminaries that the court thought was important to go over and make sure that you understand your rights and that there aren't any opportunities that I just wouldn't want there to be a later point where you felt that you didn't know that and would have wanted to do that. So the series of motions you filed, one of those is you caption it as a desire to change the venue of the case. Now, venue changes in Kansas are extremely rare. In fact, not even the Carr brothers got a venue change. And the Supreme Court affirmed that with, I think, Justice Johnson dissenting. I know I don't know if you're familiar with that case, but it's one of the most notorious cases in Kansas history, and the pretrial publicity for that
You see, this
Was
has nothing to do with publicity, though. This has to do with the fact that I cannot get a fair trial within your. As a matter of fact, I'm so scared to even come into your county because last time I had court, I was pulled over and withheld from court. And as a matter of fact, if you look at the ROA report on 1A MR 102, it says you presided over that hearing.
okay. So let me get back to the reason I'm explaining is the normal reason given for a venue change in Kansas, in fact, is usually pretrial publicity, because it goes to the issue of the jury pool. You understand that with a jury trial, it's not the court that's deciding.
Right, but everybody that I'm going to name accusations against has very high standing, very high sociability within your guys' second judicial district. I mean, we're talking about Judge Eric Campbell. We're talking about you. We're talking about Blair. Where's his name? Hold on, give me a second. Let me find his name. I mean, Blaine Carter. We're talking about several upstanding individuals whose everything I'm getting ready to question in front of people who know all of you guys to be very high upstanding citizens of society. I can understand if you don't want to change the trial. I can understand why anybody wouldn't want to change the trial. But I am going to argue the fact that it should be changed.
Yeah. Well, some of those are a little bit different concerns you have. For instance, some folks you mentioned may or may not be people who would be witnesses that you could call. I mean, just because you want a certain witness,
but like you just said, sir, you yourself can pick and choose who can and can't talk. The orders go through you. All of it goes through you.
Yeah, well, that's not, it's not a question of I choose who talks. I have control over what exhibits are admitted into evidence if there's an objection to.
And the state's going to object to everything that I try to submit. I mean, we can both see what's coming. I mean, today they were asking if I was in jail in order to see if I was in jail, probably to freaking make this go away. Who knows? I mean, that's how scared I am to enter your county, to even go through your county.
Yeah, well, but my point is that those rulings, whether a piece of evidence is admissible or enough, are a legal situation. So the example I gave you of why the Constitution wasn't admitted, because it's not relevant to that case that was being tried. It didn't pertain to what was going on. The same thing with a trial that you would have. The trial, again, we're talking about the criminal matter, is about these three allegations that are here. Now, obviously,
actually, where the trial starts, sir, should be the stop, which was illegal in itself, and because it was known that I was in that car. I'll present all my evidence. It's just that I'm telling you that right now, on record, that I cannot get a fair shake at all. Not within the second judicial district at all.
Yeah. Well, but there's an example. A question about the stop would not be dealt with by the jury. That is a question of perhaps a motion to suppress, a motion to dismiss.
But we'll get to that. That's my constitutional challenge, actually, because, I mean, half of the sheriff's departments that I've received notification back from don't even enforce window tint laws. Another half of them, or actually another 40% of them, don't have window tint meters. And then 3 of them have written tickets. Now, granted, I'm still waiting on almost 60 sheriff's departments to respond, including Jackson County, to respond to my Cora requests. But we've seen where my Cora requests get me within that county. I mean, your county sheriff, your county clerk, your county court clerk, your county attorney are all teaming up against me. All of them.
Yeah, but
Yep.
again, I go back to your question. So your motion to challenge the constitutionality of the tint law, your motion to challenge the obstruction law, those are legal matters that are addressed pre-trial in a motion, say, again, with regard to the stop itself, the most common motion that is often seen is a motion to suppress. Obviously, if the evidence is suppressed, that often leads to a dismissal, depending on what evidence is suppressed or not. So a lot of the things that you're talking about are pretrial issues. The jury won't be making a decision about the constitutionality of the tint statute.
But I
They
mean,
won't.
they should be allowed to this right.
Yeah, but that's not the law, sir. The jury is to decide facts, not the law. And
Okay,
so,
but in this instance, the extrajudicial proceedings and everything that's gone on, not just in this case, but all the cases point to I don't get a fair trial in Jackson County. I mean, whether it's pre-trial or not.
okay, but these are just trying to make clear where these decisions are dealt with. That a jury, this is a common misperception among some pro se litigants that a jury decides all these issues and that they'd hear all these issues.
Well, you see, here's my biggest problem. Is that this is malicious, wrongful prosecution. Therefore, it should definitely go to a jury.
Well, that's what we just decided here. You will get a jury trial on the facts of these allegations. But these other issues that you've raised will be considered by the court and ruled on in advance of trial so that both parties kind of know where they sit. Obviously, if evidence were to be suppressed, then the state may have to dismiss the case. They may have to change their strategy. It's hard to tell. As to the constitutional challenges, the same thing. Obviously, if the court were to rule in your favor,
I'd rather just go straight to jury trial and find out if they even find me guilty, because at this point, I believe I can show the culpability of everybody within my case. And I mean, I will raise this to, like you said, I mean, I do have the challenge, so I will definitely make the challenge, but I'm just curious as to if I don't do anything and this goes to jury, if your guys' prosecutor even enters that video evidence into evidence. If not, I should make it known that I have it audio recorded, so you can hear me screaming for Mr. Lake. You can hear me saying I have court. You can hear him asking me, please, please, for 5 minutes, please just take me to court. Write us our ticket there, please, please. You can hear all this on my audio recording. So...
well, the audio recording may be a piece of evidence at the trial. They commonly are. But here's the issue again. These legal issues that you've raised need to be done pre-trial. They can't be saved for later because then you won't preserve them for the Court of Appeals if there were rulings against you.
Oh, I got you.
The constitutional challenge in particular is a matter for ultimately the appellate courts. And so the only way to set that up is to file your pretrial motions, get those addressed, and because
But you see, that's my point, is I want those constitutional challenges to go to the courts. I don't want you guys to be able to just sweep this under the rug and say, oh, it never happened. You see, that's my biggest problem right here, is that's what I feel like is trying to happen is, oh, this never happened. We'll just throw him in jail, throw away the key, and he's good. We're good.
Yeah. Well, again, that's why I'm having this discussion with you. By filing these motions, you certainly have them of record then. They can be ruled on. And if they don't go your way, they ultimately can then go on up to the Court of Appeals of the state of Kansas. But we can't preserve those things if we don't do them in the correct order. So that the court does what it's supposed to do, and then the jury does what it's supposed to do in terms of bring evidence.
I was going to ask, who do I enter my evidence to back up the constitutional challenges then?
Well, one of the things that we need to talk about here today is scheduling. Typically, here's how that works here in Jackson County. I sit down with the attorneys or the litigants in your case, and we find a date for a jury trial. Prior to the jury trial, we set additional pretrial hearings. Those hearings are where you would present, for instance, I know that you've indicated you're working to collect some statistical evidence that you feel will support this question of the constitutionality, let's say.
Right, but we're talking about discovery now, right? And the Kansas statutes say that if I don't request discovery, I don't have to show anything.
Well, but you just asked, how do you present these things you're developing, like your statistical evidence, so that you can argue, Judge, here's why the 10th statute's unconstitutional. It's this, and it's under-prosecuted, and so my statistics that I've gathered show that. That would be done at a pretrial hearing. Again, the jury's not going to be deciding the issue of the constitutionality of the 10th statute based on statistics that you would present. So that's how we would do it. We would have a pretrial hearing where you could present your legal arguments. Those pretrial hearings can include facts. Commonly in a motion to suppress, they do. The officer will testify in a motion to suppress, and he'll be asked questions about the stop and so forth. And then the legal arguments will be combined with that to say, well, Judge, this should be suppressed, or no, it shouldn't be suppressed. So to that extent, there are some pieces of evidence that are discussed at those hearings.
You see, and I guess that's where I'm having my biggest sick of stomach issue, is that I know this will get dismissed within court, but why doesn't anybody want this to be made public? Why? Like, I mean, I guess I understand what you're saying. I get it. I'll file all my motions to suppress and everything within the next week.
Well, that's certainly something we can talk about you doing if that's your desire. Again, that's why we're having this discussion so that you know how best to exercise your rights and that you don't get any surprises. Okay. This discussion kind of began with your venue motion, and I've read it. Again, it doesn't set forth a reason under Kansas law to change your venue. Now, what you're really talking about possibly, but I'm not sure, is whether you feel that there should be recusal of a judge or judges presiding over your matters. That's not a venue question. It's a totally different question under Chapter 20, which has a specific provision dealing with requesting the recusal of a judge or judges. So obviously I'm trying to make clear as the judge, I'm not your attorney and I can't give you legal advice, but on the other hand, it seems plainly obvious to me from some of your comments and what you wrote in your venue motion that you may really be talking about seeking recusal of a judge or judges. Again, you can certainly file such a motion, and there's a procedure for considering that motion. It's 2311D, I believe, is the statute. And the way that works is, again, you file your motion with the judge that you want to recuse that's presiding over your proceedings. That motion is then heard and considered in an informal proceeding that's not recorded. A ruling is then made on the record as to whether the judge is going to recuse or not. If the litigant doesn't like the result of that, then under that statute, they file an affidavit and take it up with the chief judge of the district, Judge Nafziger, who sits normally in Oskaloosa. So that's the procedure for that particular type of question. But with regard to your venue motion, I'm going to deny the change of venue, quite frankly, because other than extreme circumstances, Kansas law and even the Constitution says that the correct venue is generally where the crime occurred, or where it's alleged that the crime had occurred. But again, some of the issues that you are raising could be addressed, as I've just indicated. So, at least at this point, in terms of the motions you filed, that then does bring up this issue of getting the motions set and giving you an opportunity to support any of the motions you want with any evidence that you think is appropriate. Sometimes that could involve subpoenaing a witness or the like. So while we certainly can get our calendars out and set a hearing to hear all your pretrial motions, we want to do it in such a fashion that you have adequate time to prepare, and the county attorney's office has adequate time to respond to any motions. And then the court can hear those and get arguments and evidence and then make some rulings. Sometimes I'm not able to make a ruling right away. I need to take something under advisement, either to do a little bit more legal research myself or review the exhibits or those type of things to make a decision. The reason I'm mentioning these is that and attorneys do the same things. If you were represented by an attorney, they're cautious about setting stuff too quickly because they want to make sure that they're prepared. Of course, what goes along with this, since I'm going to deem this your arraignment, as we've had this discussion, you do have your speedy trial rights. And since you're free on bond, we have 180 days to get the matter set for a jury trial, barring a waiver of that. And so I certainly think that we can, obviously I'm sure we can give you a setting well within the 180 days. Of course, one of the issues we'll need to determine is how long the trial might be. In other words, one-day trials are fairly easy to set on our calendar. But when we have multi-day trials, they're more difficult because you have to find several days in a row to do that. Normally, a trial like this that's alleged here a misdemeanor where we're only going to have 6 jurors would be a one-day trial. But I always query both sides what their thoughts are on that, and then that kind of dictates the trial date we get, and then we sort of go backwards to set those hearing dates. So in your mind, Mr. Brewer, do you have an idea of how long you think the trial might last?
My side might be a day and a half.
Okay. And Ms. Gerhardt, I assume you don't disagree with that?
No, Your Honor.
All right. So that's fine. That's not unreasonable. When we're there a day and a half, what we do is they just have to be set for 2 days. So we know there'll be other motions and stuff, but let's talk about, I've got the calendar here. Mr. Brewer, you have a calendar in front of you, or you're comfortable with the dates we might offer?
Yeah, I'm comfortable with whatever dates.
All right. All right, so my clerk has done the calculation, and I don't think we'll have to go that far out, but at any rate, speedy trial would give us the ability to have a trial anytime between now and August 23rd. But we'll try to find something earlier than that because I understand, and reading your motions and our discussions, that you would like to get this addressed. And so I'm going to start. I've got the calendar here in front of me, and I'm going to have, last Friday we were here on a docket, and we added some, that's typically where we add these jury trials, and so we've added some in and started to fill up the calendar. But
Judge, I can have just a second to run across the hall and grab that office court calendar. Make sure I'm not double booking anyone.
Yeah, no, take your time. It'll be a while before I'm looking through my calendar right now for 2 days. Okay, like that. So, Mr. Brewer, there's some silence here, and that's just because I'm trying to flip through my calendar. So our connection is still good, and I can hear you clearly.
Okay.
Because we ended up sucking up some of our, even our May dates, because we had a multi-day trial. We set a 4-day trial in late May, and that has eaten up some dates. And then we have a dockets. Let's see here. What are we doing? So potentially, and I'll get the state's opinion on this too, but it's looking like May 16th and 17th may be available on the court's calendar. Let me double check to make sure. Yeah. So it looks like May 16th and 17th have good availability on the district calendar. Obviously, I assume the key witness is Deputy Hanukkah. There may be others, but I know the county attorney's office keeps a list of when deputies are going to be at training. But from the state's perspective, do you see any problems with this May 16th and 17th as potential trial dates?
That should work, Judge. It doesn't look like Deputy Hanukkah is off based on the calendar that we've had at this point. I know we will be short one attorney that second day, but I think it should be okay.
Yeah. Mr. Brewer, what do you think about that?
I went from my brother to hear that, so.
Okay. It sounds like
sorry,
we're Mr. Brewer, Ms. McKnight is indicating that a relative of yours is getting married, I guess Saturday the 18th?
No, the weekend before.
So the 12th, or the 11th and 12th?
So I don't know if we'll be back.
Yeah, hold on.
Okay.
Let me check the. Should be able to make it back.
All right. It sounds like, if I heard you right, you kind of were leaning maybe away from the phone, but you're indicating you're comfortable then with being back for the 16th and 17th, with this wedding apparently being on the weekend of the 11th of May.
Yes.
Okay. So let's then talk about a pretrial date. Theoretically, if we go with that trial date, the way we commonly, and in this case, because, quite frankly, you've already got a fairly thick group of motions on file, we want to make sure that there's plenty of time, and that if other issues develop afterwards, in other words, what I'm suggesting is that we set this early enough that we could have potentially two pretrials. A pretrial, I'm thinking in late March, to deal with pretty much everything that you're thinking of right now, including some of the stuff you've already started to develop, and any other motions you want to file. A typical date that we would take those up is our regular motion and arraignment docket on March 22nd. Let me look at what the afternoon is looking like, though, on that date, because that'll be a hearing, obviously, just like the jury trial, where you'll need to be here in person.
Do I have any assurances that I'm not going to be stopped outside of court on my way, taken to jail in order to effectuate a guilty plea or anything like that?
Well, first of all, you couldn't have a guilty plea entered without your personal appearance to enter it.
There's a lot of things in this case that shouldn't have happened that have. That's why I'm asking for assurances, because, I mean, from what I've read of the statutes, I don't have to be there except by phone, except for a trial on the merits. Therefore, I should be able to appear by my attorney in fact until a trial on the merits.
Yeah, well, first of all, you're not going to appear by your attorney in fact at all. She's not here to appear on your behalf. For a criminal evidentiary matter like this, you need to be.
Okay. Was my motion for change of venue denied?
Yes, sir.
Okay.
As far as your question of assurances, I have no power to order law enforcement officers to do anything. If a law enforcement officer believes they see a violation and they make a stop or they make an arrest, in advance, the court has no power to say this person has a free pass to come into our county. Now, certainly I would hope that there wouldn't be any issues, but in terms of your question of assurance, the court's not in a position to give anyone an assurance of avoiding a potential stop if some law enforcement officer. And one of the reasons for that, sir, is keep in mind that I don't have any control over the law enforcement officers. They work for agencies such as the sheriff's office or the tribal court or the highway patrol, etc. There's a whole plethora. They're law enforcement officers in Hoyt, they have their own police department. There's a whole police department here in Holton. Obviously, I certainly hope that you wouldn't have any problems in getting yourself here. Well, the 22nd is pretty clogged up. So let me look at another date. If we were to take this matter up on March 15th, would the county attorney's office have availability? That's a Friday.
I believe so, Your Honor.
I've got a civil matter pretrial conference in the afternoon. Sir, do you think that March 15th would work for at least an initial pretrial? I understand you may end up filing additional motions, but at least to take up and present your evidence and such on the 15th of March?
Sure.
Okay, so I'm going to set this at 2 o'clock. And I'm not going to set anything else that afternoon if I can help it, so that we have plenty of time. So, again, any additional motions, do you think that you could get your motions on file by March 6th?
Should be able to. I was going to try to have them done by the end of this week.
Yeah, and that's fine. I'm just trying to build in some time so the county attorney can make a response to that. Now, because sometimes that dictates the witnesses the county attorney brings, because it's sort of a odd deal the way this works, particularly with motions to suppress. That might be your motion, but the state's the one that produces the evidence. And so they usually might have a law enforcement officer here, and then obviously that's your opportunity to also question that person also. But if you think there are specific witnesses that you need to help support your motion from a factual standpoint, then, you might, you can also obviously have access to issuing subpoenas to witnesses. And the only reason I mention that is that does take a little bit of lead time, especially if they're not a resident of this county. So, for instance, getting someone subpoenaed out of Shawnee County is notoriously time-consuming, just because it's a large urban county and the process servers, it's not always a priority for them. So just something to consider. But for now, we're going to set a pretrial March 15th at 2.
Now the question is, the bigger question right now is the judge or the state going to require me to issue subpoenas for every core request, or can I just turn in the printed emails?
Well,
because if I have to issue a subpoena for every single sheriff's official that sent me, I'd be really costly and time-consuming.
Yeah. Well, with regard to that, I think that type of evidence goes to the issue of whether those, I'll call them statistical responses, would fall within the business records exception to the hearsay statute. That would be the most common means of offering an item like that, is through, say, a business records.
Okay, so rather than my core requests, I should submit a business record subpoena to all the sheriffs?
Well, that's not what I'm saying. You certainly can do that. My point is that it's possible that some documents produced through Cora would comply with the business records exception. See, the business records exception doesn't go to a business record subpoena. It goes to the type of record in terms of its admissibility. So a business record is simply a record that's a contemporaneous record, usually, of whatever's going on in that business. So let me give you an example. Let's say a business pays a bill with a check every month on the 15th. That check, if it's presented to prove that the person paid that bill, would come in probably through the business records exception and maybe some others, because it's a record that's kept in the regular course of business by the person. So my point is that some of what you're talking about may fit within that exception. Obviously, if you choose to use business record subpoenas, you're welcome to do that, because that can be another avenue of admissibility. And as a litigant, you have the right to use subpoenas as opposed to a Cora request, because Cora requests don't require there to be a case that you can put a caption on and have the clerk's office stamp it. But a business subpoena has a particular process to it. Obviously, you are welcome to use business subpoenas if you like. The issue is the court can't rule on the admissibility of something that's offered until it's offered, which requires that the state have an opportunity to see the proffered Exhibit 2 to see if they're going to object or not. Keep in mind that hearsay is frequently admitted at some hearings because there's no objection. And if there's no objection, it comes in. So sometimes what people do is just they get a stipulation, here's some of my exhibits. Do you have a problem with any of them? And if the answer is no, I don't, then boom, they can come in. So you can, however you deem appropriate, but you certainly have the power of subpoena, and so you have the right to use subpoenas to gather what you want. Now, when I mentioned subpoenas, I was thinking more in terms of a human being as a witness that you might want to call also. But you don't necessarily have to call human beings to get in some of these statistics. Again, it depends on how they were collected or how they were presented as to whether they might meet that particular exception. So hopefully that answers your question. So we've got this time. We've set your a trial. We've got this pretrial hearing where we'll take up the rest of your motions, because again, you have these two constitutional challenges that you've got in there, and we've dealt with the venue, but I think there was another one in there, but I don't have my list in front of me of.
It was a waiver of preliminary hearing in case they made my charges.
Yeah, and obviously this is a misdemeanor, so we don't need to worry about preliminary hearings, since you wouldn't have one. That's right, you had that one in there. So I think maybe that's, at this point, those are I'll call them the meaty motions that may have some evidence connected to them. Again, you could also file if you've got a ground set out as a motion to suppress, because that deals with a different issue. The constitutionality of the statute is one thing, but even on that, there's a question, for instance, on the tint violation. One of the questions the court's going to have is, do you have standing to assert the constitutionality of the tint statute since you were a passenger in the vehicle? I don't know the answer to that question. That's a question I'm going to ask both sides. I'm going to say, does Mr. Brewer have standing to raise the question of the constitutionality of the 10th statute? Now, with regard to the obstruction statute, clearly you have standing because that's one of the charges against you. So I don't think standing's an issue on that one.
But I mean, do you want me to answer the standing question right now? Or is that because I mean...
No,
okay.
Because I want to give the state an opportunity to do its research. I want to give you an opportunity to do your research and say, you know, under this case, I do have standing, and if you do, fine. We move on to the merits of it. But that's just one of those issues. But what I was trying to get at is neither of those go directly to the stop. In other words, if we're arguing it's a bad stop because, for instance, you've suggested an issue of, I'll call it profiling, you know, that could fall underneath this Gray case, State v. Gray, 306 Can 1287. It's a 2017 case. It was the first time that the Supreme Court dealt with this issue of what we'll call profiling in terms of stopping someone. For years, the state of Kansas, by statute, has required police officers, for instance, to gather what I'll call statistical evidence with regard to stops they make and such. And prior to the Gray case, that had sort of been okay, we collect it, but who gets it? Who cares? After the Gray case, what the court was saying is, in the right circumstances, we're going to give litigants an opportunity to say, hey, I think I was profiled because I'm African American, or I think I was profiled because I'm a woman, or, you know, whatever those various things are. Now, that's slightly different than your issue about tint, but my point is that to challenge a stop, because in general, a pretextual stop is constitutional. In general, a pretextual stop. In fact, under Supreme Court precedent, if the officer thinks that there's a violation, but he's wrong as a matter of law, that stop is still valid under a North Carolina case that went to the U.S. Supreme Court. Also, there had been earlier case law that suggested that if the officer is wrong from a factual standpoint, and he has a good faith belief, I mean, these are generalizations, that still may be valid. But that's where we get into this issue of challenging the stop. That's typically done with the motion to suppress the evidence, and it may deal with issues that have nothing to do with the constitutionality of the statute. It may deal with issues of, based on case law, the stop was illegal because of, well, I don't know, profiling or something else. Attorneys have all sorts of issues for that. One of those is there wasn't probable cause to make a stop because there wasn't a violation. This court has suppressed evidence in several recent cases because the officers didn't have a valid reason to make a stop. So whether that's true or not in your case, I have no idea. That's just an example. Now, that raises a totally different issue that I think we need to address, that I normally would address with people who have an attorney too, as we talk about trial and pretrial. And you've gone back to this issue of discovery. Certainly in the criminal case, the county attorney's office maintains an open file policy, and you are entitled to the same stuff that the county attorney has. So these videos you've referenced, that could include obviously the dash cam video, that could go back, earlier before you were even stopped. Most commonly, the dash cam videos go back at least a minute. In other words, they're always recording, but they record over each other. But then if the officer turns his emergency lights on, then boom, they start burning the thing. And so that they'll go backwards approximately a minute to 30 seconds, depending on the setting. So there could even be something showing the precursors to the stop on those. So clearly, you have a right to the discovery that's already in the county attorney's file, and that in many cases would be used to support a motion to suppress. It's common for attorneys to say, and judge, here's the video, I want you to look at it. You've seen my arguments, and based on that, make a finding this way or that against me or for me. So in your case, we have this unusual situation where you're representing yourself. We've discussed that. So we do need to get the discovery to a point where the same thing I would do in it with an attorney. What I ask the attorneys is, are you satisfied with the discovery you've got? Do you have everything you need? And sometimes they'll say, no, I need this, or I'm asking the county attorney to hand over an additional thing that's not in their file. It appears to me, because you're here by phone, but I can see in person that looks like the county attorney's office already has a complete copy of the discovery sitting on their desk. Normally, they just hand that to the attorney. You want it? So, Mr. Brewer, do you have a problem if we give this discovery to Ms. McKnight?
No, I mean, I'll fax the county attorney everything I plan to submit then.
Well, again, certainly the defense is allowed a certain trial by surprise, but you are entitled to the discovery whether you use it or not. And since Ms. McKnight is here, if you were here in person, Mr. Brewer, and given that they have the copies, I'd go ahead and direct them to give it to you. If you entrust her to take that discovery information, okay, then I'll have the county attorney do that. So just so I'm clear with everybody, and Ms. Gerard can tell me, I mean, I see that there are 2 video or CDs or DVDs, whatever, sitting there. What about the paper discovery? Okay.
I've got it right in the desk.
So what Ms. McKnight is going to be handed is the same thing that the attorney would get if you had an attorney. It's from the county attorney's file. Now, the reason I'm trying to go into detail here is there may be discovery that you want that the county attorney doesn't have in their file. For instance, in looking through your things, and we can ask the county attorney, but it appears that you are also asking for what I'll call the jailhouse video. That is not a standard piece of discovery that they typically make a copy of. However, we occasionally do have those requests for that. And if there's a request, then usually the county attorney, sometimes they might object, but most of the time they're just going to go and see if they can find that for a person. So, Ms. Garrett, do you know what the 2 DVDs you have are for? One's a body cam, one's a dash cam, I'm assuming?
That is correct. One is the body-worn camera, and it's labeled as BWC, body-worn camera, and the other is parking.
Okay. So here's how that would typically be handled, Mr. Brewer. If there's additional discovery that isn't in the county attorney's file, but you believe could be, I don't know, exculpatory or relevant or whatever, just like the attorneys, you would make a request to the county attorney, I need this additional stuff. Within, usually I never hear any complaints about that. So I can't really tell you what they're giving out and what they're not. But again, it's not uncommon that there's a request for the jailhouse video. As you might know, there are videos. Now, those don't have an audio to them, but there are such things. Most commonly, they're requested in a DUI case because they depict if the person is going to argue, hey, I really wasn't drunk, look at the video, members of the jury, that would be another video that would be available. So my point is just because you get it from the county attorney doesn't mean it's the end-all, be-all of discovery that could exist and that a criminal defendant could request. That's my only point with regard to that. But we're going to see that Ms. McKnight gets this packet of information before we adjourn here today. She'll walk out with it, and I assume be headed your way, and you'll have it. Now, sometimes even the attorneys complain that those things are downloaded with various computer programs, and so some of that's proprietary. Generally, I found that I can play the videos that they've given me, but sometimes I have to play them not through the Microsoft player, but some of the other players that are on the internet. My point is two things. One, the minute you get these, you should view them, because occasionally what we've had happen is they don't copy correctly. Well, we won't know, the county attorney won't know that you didn't receive a good copy that you can view unless you tell us. Billy Rourke did that one time where he was sent the wrong one because there was a typo on the date. And by the time Mr. Rourke got around to looking at the video, he realized it was the wrong one. And the video he wanted had been destroyed because more than 6 months had passed and so forth. So I'm not trying to tell you your business, but in terms of the format issue and stuff, I assume you'll probably look at those fairly quickly. Again, if you have a problem, your relief is through the county attorney's office to make sure that you have that discovery. Do you have any questions about that?
No.
Okay. All right, let me put it this way then. I think we've had quite a long discussion, but I think we've gone through a number of issues. We've got your jury trial set. We've got your March 15th pretrial set. At the 15th, we can talk about whether we need another pretrial. We probably will, because we'll want to look at the jury instructions, and typically I won't draft the jury instructions till they get a little bit closer. But both sides have an opportunity to have input into the potential jury instructions, assuming that we get that far down the road. So we'll probably set a pretrial, a week or two before your trial, just kind of as a double check. Do we have everything? Are we ready? Are the jury instructions at least drafted? Are there any procedural things that need to be dealt with? But at any rate, with regard to then what we've discussed in our plan here, Mr. Brewer, do you have any questions or things that you think we need to resolve while we're on the phone?
Not at this time.
Okay. Ms. Gerhardt, what about the state? Do you have any questions about anything we've discussed or anything that you think you need in this matter?
I don't believe so, Your Honor.
Okay. So what I'm going to do then is I'm going to close this hearing with regard to this criminal case of 19 CR 26. Now we're going to turn to a case that's 19 CV2. This is a civil case And Ms. Gerhardt, you're welcome to leave if you just want to give Ms. McKnight that stuff, because Ms. Morrissey is here, Mr. Brewer. She's the county counselor and has entered her appearance for the Jackson County defendants, I guess is what I'll call it, in this matter in 19 CV2. This is also being recorded at this time. We're really here for what I'll call a scheduling conference, at least to talk about it. This is obviously a relatively new case in terms of a civil filing, and the answer, Ms. Morrissey filed her answer here recently. I looked at it again this morning.
Did you read
on the answer? Yeah, I read the answer.
Did you notice that on number 16, paragraph 16, they deny it, and yet all it says is KSA 45-222C puts the burden of proof on the public agency to sustain its action. So my question is do Kansas statutes not apply in Jackson County, or what's going on here?
My response would be, as an old civil attorney who used to be a county counselor myself, I call the answer a general denial. So they just denied everything. But no, it doesn't mean that, Mr. Brewer. You're right. The statute is controlling, but it's not uncommon to file what I call just a general denial, because they're denying that perhaps, and I don't have it. In other words, I have to set them up and mirror them. So I understand your question, and that's a fair question. But no, the statute is still applicable. It's just this general denial saying essentially, hey, we're going to contest these proceedings because we think we have a defense, something along those lines. Is what they're saying in that, and particularly because this is a declaratory judgment action, which is really, I'll call it primarily a legal one. In other words, a deck action really is about an interpretation of a statute. In this case, it goes to the Open Records Act, as you've indicated. And so that's one of the reasons we're here today. Normally in a civil matter, we probably wouldn't set a scheduling conference for some time after the answer was filed, because the parties engage in what's called discovery, using subpoenas, requests for admissions, interrogatories, requests for production, depositions, etc., to develop the record that they want to do their case. Now, in a deck case, usually that's much more limited. We don't really think about there being necessarily full discovery versus a desire just to essentially tee up the legal issues, if you will, which is sort of what's contemplated in the Open Records Act. In other words, that you can go to district court to challenge a decision made by a public entity in response to the Open Records Act. So my purpose here today, then, at least on this one, now that we have an answer filed and we've got Ms. Morrissey on the defense side, and of course, I assume, Mr. Brewer, obviously it's a civil case, so we really don't even get into discussion about you representing yourself, because and you're not entitled to have an attorney appointed to represent you, so that's fine. So anyway, we need to figure out from both sides if there's any discovery required, even if it's more minimal than normal, to get this to a point where we can have I'll call it a hearing/trial, because it really will be somewhat in the aspect of a trial if we need to get there. And I guess what I'm why I particularly mention that is in looking at, this is a area where one of the Cora situations that's being raised goes to a statute that was just amended effective July 1st, 2018. And what I'm speaking about is 45254. It had been created, I believe, back in 2016, but in 2018 session they amended it substantially, a lot of the language is there, but what they did was, and the statute I'm talking about is a statute that deals with hearing audio tapes and viewing videotapes. Under the prior statute, there was, among some folks, a right to view those, but there was no deadline for that, if you will. Well, then we had the situation happen. I think that's why the legislature did it down in Shawnee County, and there was a case over in Johnson County where it was sort of an issue too, and so they amended it and they put in this 20-day time frame of the, if you will, the agency responding to that. But what's unusual about that statute compared to the rest of the Open Records Act is most of the Cora, especially when it was written, obviously was focused on documents and producing those. And here we have a statute that doesn't require them to be produced, rather it requires that they be available to view.
Mr. Marek, Your Honor.
That's Judge Marek to you, sir.
I'm sorry, Your Honor. I'm sorry. But 219, right at 45-219A says any person may make abstracts or obtain copies of any public record to which such person has access to under this act. So therefore, it doesn't matter. They don't have to explicitly state you have permission to do this. You have permission to get copies, because the permission is already there well before that statute was written.
Okay, but my point in talking about 254 is simply this. Because it's a little bit different, in other words, here's the typical Cora litigation. You make a written Cora request for documents, and if the agency provides them to you, then sort of we're done. If the agency says that we either don't have the documents or we have an exception, then that's why we have Cora litigation, where you say, hey, here's the written request I made, and I believe that there's not an exception to that, and I didn't get it, so Judge, I'm asking you to order them to provide it. What's different about 254 is, and I've looked through everything everybody's filed in this case so far, which is really just two documents. There's your petition where you've got some exhibits attached to it, if you will, and then there's just the answer. But obviously under 254, there's a requirement that the person who wants to see the records make an appointment to do so. And so from a discovery standpoint, I don't know if you made a request to view the documents, I'll call them documents, videos, audios. That's different than obtaining copies of them. And so Cora treats that differently. And I simply, for instance, that would be one of the court's questions in there is, well, folks, did Mr. Brewer ask to come view these, and was he provided an opportunity to view these items? And I'm specifically talking about videos because that's what that's focused on.
Okay,
And
now the judge is going to have to, or the jury's also going to have the chance to decide on whether Jackson County entities, well before they ever gave me permission over the phone, because they never sent me a letter, but well before they ever gave me permission to view anything, as you say, they even told Bonnie that my stuff wasn't public record. They went through so much in order to try to force me into this petition. And now you're telling me that Cora's murky, kinda. That's kind of like what it sounds like you're saying, is that Cora is murky, and to me, Cora is crystal clear.
well, I understand, though, I don't think that that's correct because there are exceptions to the Cora, and they're regularly litigated. Now, whether those exceptions apply, because you did include in your exhibit the letter you got from the sheriff about he cited the Cora himself, and then the county attorney's office did also. But that's really not what I'm talking about. I'm talking about that issue of, with regard to 254, that's totally separate and apart from other Cora questions, which is, did you have an opportunity, did you request to view the videos, and were you offered an opportunity to do so or not? I don't know the answer to that question, but that's key here.
So, so pretty much you're giving me the state's argument because that's exactly what happened. That's great. That's awesome. So it sounds like I'm going to get a fair shake in this matter too.
Well, Mr. Brewer, all I'm doing is reading the statute. 45254 clearly is a totally different part of the Open Records Act and deals with a specific way. And so, yes, I'm going to ask you about that, because what's going to happen if the state says, oh, we gave him an opportunity, then you need to know that in advance if that's what their point's going to be. And that's why we're talking about discovery. I don't know if you received such a letter. I don't know if they're going to say, in fact, we've got something where we had an appointment with Mr. Brewer and he didn't show up, or he did show up. I don't know that because it's not anywhere in here. Because here's the thing. You have a right to view them regardless of the other Cora stuff. And I need to know whether you're going to argue that point also, because the legislature clearly intended to give you a right under that can be exercised by viewing it. And so that's why I think it's an important issue, because it changed the way things were viewed. You know, before that, generally the agencies didn't make much of an effort to quickly arrange a viewing. Generally, they didn't. Now, under the new mandate, which would apply here, there's this 20-day period that applies. I think it's also important because here's the legal question. By making that change to Cora, because the court in construing Cora is going to have to construe the whole statute to the extent we have any questions about what you could get or not, when you should have gotten it or not, we're going to have to look at the whole statute.
But can't this whole thing just be avoided by Jackson County saying, hey, yeah, we'll give him a copy of everything he wants?
Well, in fact, it appears that obviously they could do that at any time if they wanted to. And now that McKnight has those videos, they may argue that. I don't know, but that doesn't change the Cora, because whether you receive those in discovery or not isn't got really a lot to do with whether there was a valid Cora objection at the time you made the request, or whether you had the opportunity to view those. But I'm not saying that Ms. Morrissey isn't going to argue that. I don't know. That's why we need to have this set for a hearing where any evidence can be presented, any legal arguments can be presented by both sides to get a ruling from the court, because here's something, DEC actions, declaratory judgment actions, are not tried to a jury. They are tried to the bench.
And you see, and to me, it's very clear that Cora tries to have an open government. And as I stated in my petition, it's very clear that what Cora's intent is. To try to extend this is to convolute Cora, to say, oh, well, there is a question that we should be able to shield our entities, to shield our liabilities, because we're our own little government. Not because it's in the state laws, not because there's ever been a ruling that says that they don't have to provide, there's even been rulings that they have to provide confidential records to those who their records belong to. So, I mean, you know, when you start convoluting Cora, it sounds like, well, now we're just trying to shoot holes in this statute the legislature meant to stand up for all the citizens and to have an open government, not just state government, but county, city, local, everything.
Yeah, well, I certainly understand that, sir. And the issue, though, is, again, the legislature in the same Cora created numerous exceptions, and those have been litigated in the courts since Cora was created back in the 70s, and then the courts make a decision. Sometimes those decisions have favored the litigants who wanted them, and sometimes they haven't. That's why we have a hearing, and we have both sides have an opportunity to present their legal arguments. Because ultimately, then it's a question for the courts to decide whether the statute is being complied with.
All right. My sister, Maria McKnight, she also has another paper from me. It's the petition for declaratory judgment, but in red I wrote in conjunction with the defendant's answer as I read it. So I just want to enter that on my behalf as well.
Okay, so she has a filing she's brought up that we need to put in the file. Go ahead, ma'am, bring it up here, and we'll get it file stamped eventually, so I can at least see what we've got. Right, and so you've kind of responded to that, which certainly we can have this filed with the court.
And then she has two more exhibits too, because the sheriff sent...
Okay, and those are part of that, you want them attached to that filing, or do you want them separate?
No, I want them attached. She has one from Bonnie Zentz to the sheriff saying that he reviewed the video, in which they denied that anybody could have had any knowledge of this, any of the defendants. But then also, there is the... I'm also entering the Jackson County Record of Actions report for case number 208 MR102, which shows that my extradition bond hearing was canceled on the 17th because I was incarcerated in Jackson County Jail.
Okay, Ms. McKnight, you have those? Apparently she's looking for those, but certainly we can put that into the record here. Okay, so I know we've kind of gone around and talked about various issues, but ultimately what I'm trying to get to is what's the soonest best date that we can hear this matter, but at a date where parties feel that they have if there's any limited discovery, because that's my point, was that action like this wouldn't have a full discovery record because it's primarily a legal question. We need to figure out a date that we can fast track this, because that's what's contemplated by the statute, but it still needs to be a date where both parties can put their best foot forward.
I also want to say by the counselor for Jackson County entering their answer 27 days after, not 21 days, kind of seems like this should have been addressed sooner. It's like they almost know that no matter what they do, they got this.
Yeah, I don't know, sir, and I don't know why you'd feel like that. It's, to the court, it's just another legal filing. It's a case that I'm ready to hear people's arguments, and I'm ready to make a decision on, and I'm happy to do it. And that's one of the reasons that this was set more quickly than normal, because you made that request. You're entitled to ask that a deck action like this be heard more quickly, and indeed we are. But there's still the opportunity for the civil litigant to file an answer, and again, that's where we are.
Right, but the statute says 21 days. It was entered 27 days after. That's what I was raising, just on record, so that it was there.
Okay. I mean, sure, you can certainly file a response or a motion based on that deadline. Okay, so let's talk about that, though. When we'll be ready on that. And Ms. Morrissey, obviously, you have to think about your client, but they're not necessarily related, but it is true that Mr. Brewer is going to be here on March 15th. Are your folks going to be in a position to argue this case at that time, or is that too soon? You need to do some discovery in this.
Judge, I don't think I need to do discovery, but I have hearing in Lincoln County that afternoon.
Okay, so you would be ready to take it up in the afternoon. Mr. Brewer, what about yourself? Clearly you're going to be, clearly you're going to be focusing on the other matter, but would you be interested in saving yourself a trip and also after we get done with the criminal matter, let's see, we set that at 2, say at 3:30, we take up any arguments and any evidence that would like to be presented on this deck action.
Is she going to send me whatever she's going to present?
If you ask her to, that's the discovery process. In civil litigation, she's under no obligation to send you anything, but she is if you ask, through a request for production or a request for interrogatories, and that's why I was talking about this time frame, because if you want to do that, like a request for production related to the litigation, then there needs to be a time frame, because if you were to send out a request for production today to her, she has 30 days to respond to it if she wants to take the full time allowed under the statute. So does that get to answering your question?
But this is the thing, is I already see your guys' argument, because she's just going to, I don't need discovery, because I know what she's going to do. She's just going to supply the one piece of documentation that the sheriff says, yeah, sure, come in, see it, come by yourself, come alone, where it sounds so threatening because he's telling me to come alone. But I'll go ahead and send a whole CD of all my recordings that, have Sherry telling me, I don't get that information, click. You don't get to hear that, click. There is no procedure for you to get that, click. Because obviously, that must not be their, I can see what's trying to happen here, and I'm appalled. But I just want it on record.
Okay, well, because Mr. Brewer, I gotta say, I understand, because the court's role here is to give each party a fair shake to make the arguments they want to make in court. And I'm certainly not trying to restrict your ability to do that in this proceeding. I'm trying to set up a thing where we're fair to you and that you get an opportunity to have everything that you want to make the best possible arguments.
I'm pretty sure that I have the argument, but all the defendant's motions answer says is deny, 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 deny. There is no information in their answer, and yet you've pretty much given me the information by way of I mean, it sounds like this case has been talked about amongst lawyers, judges, and everybody in Jackson County. I mean, and as a matter of fact, I think I'm just going to go ahead and ask for a writ of mandamus to move all my proceedings out of Jackson County.
Yeah, I mean, sir, you're certainly welcome to file whatever legal proceedings you want. Again, I've given you a date to present this. It's just we don't make these decisions, the judges don't, by, you file something and the other side doesn't get to respond and doesn't get to present their arguments. I'm sure Ms. Morrissey's probably going to file some kind of written brief. I don't know, but that would be pretty standard. That would detail any statutory authority, any case law authority that she believes is going to support her side. And you have the opportunity to provide same thing, more case law or arguments and or what you just referenced, the items that you're talking about where you had these recordings and how you responded to. And so the whole point of that hearing is to allow the sides to hear the evidence, cross-examine the evidence.
But you see, they're technically, like you said, this is a declaratory action. This should just be decided based upon the legislative intent of the statutes, the statutes themselves, and previous case law. I mean, by saying that these people even have an argument, by trying to tell me that these people have an argument, when in a declaratory judgment, they're required to serve me their brief 21 days after I serve them, which I still haven't gotten. All I've gotten is an answer. So you're sitting here telling me that the state, that Miss Morrissey is allowed to do this stuff.
Well, because there's not really a deadline for filing a brief. The answer had a deadline, but as far as a brief for a bench trial brief, it's not uncommon for parties to file those briefs on the day of trial because it's legal authorities that they think are important to the court to consider in making a decision.
But I mean, you see, they haven't given me any of this information, but you've raised their question for them in this hearing. Even though it hasn't been presented to the court, even though it hasn't been presented to a jury, even though it hasn't been presented to me, you just raised that they're going to bring up the fact that under 2254 or 45 254, whatever it was, that they showed you or gave you the chance to see. I mean, you see, you're going off of one tiny little statute, my whole petition. There's obviously no way you're going off of my whole petition. Otherwise, you would see that, I mean, the Kansas Appeal Courts has said that if they are entitled to this anyway, they are entitled to it through court. I mean, it's pretty, that to me, that's like, boom.
Well, Mr. Brewer, I think that you misunderstand what judges and courts do. I've read your entire petition and I've looked at your authorities, but I'm not going to make a ruling on those authorities without the other side having an opportunity to say that they have countervailing authorities.
They've had 30 days to submit a brief. 30 days. I mean, you see, this is where I'm saying that I'm never going to get a fair shake in Jackson County. They feel like they don't have to abide by anything. And it seems like the court agrees with them.
Sir, I've never said I agreed with them. What they filed was an answer. It's not a brief.
Right.
It's in proper form. Now, whether it was late or not, file a motion for default judgment or file a motion, and they can file a motion
motion for declaratory judgment, or a motion for what's it called? Let me find the statute real quick.
But here's the thing: they can then respond and say, we want to file an answer out of time. I don't know what they're going to do. But the reason I mention these things in advance is, sir, understand, whether you like it or not, I've been an attorney for more than 20 years, and so I've litigated a lot of cases. I've dealt with a lot of issues, and so I kind of have a feel for how litigation works. And my whole point of having this discussion with you was to make sure, since you don't have an attorney representing yourself, that you have a complete understanding of the proceedings so that nobody does take advantage of you. Now, as far as 45-254, clearly it would seem prudent and an expectation that the judge reviews the statutes prior to having a conference about a case so that I can ask intelligent questions and so that I can tell attorneys what I expect of them. Because I wouldn't want to come to a hearing and nobody mentioned 254, because it seems that the legislature created it for a reason.
But you see, I mentioned 254 twice in my own pleading. I mean,
Indeed, you did.
I know what 254 is. I mean, I know that all this together means that I have a right to this body cam footage. But the fact is that Jackson County feels like they do not have to abide by Kansas statutes. I mean, by denying that people have, you said it's an outright denial, just a basic generic denial. But to me, when somebody says we deny that, especially when it's a suit against a county sheriff, and they say we deny that they have constitutional rights, we deny that this statute exists, we deny that we have to follow the law, then at that point, it should be very clear and concise to any judge that they are trying to convolute and circumvent whatever they can in order to not produce.
Yeah, well, I understand that from your perspective, but I can tell you that the objections, you've attached it to it, the letter you got from the sheriff, the letter you got from the county attorney, those you could find in the files of many sheriff's departments in Kansas and many county attorneys' offices in Kansas. The response that they made in those letters wasn't unusual for Jackson County. And so I don't think you can view it as this is a personal thing with regard to you. It's very common for the sheriff's departments and or county attorneys to say we're not going to disclose this because it's subject to an ongoing investigation. That is very common. So it's not personally picking on you, Mr. Brewer, that I know of. I mean, again, I've been in many litigation and I've seen letters like that before. I've not had to rule on this specific issue before, the way it's been presented, because oftentimes there isn't necessarily any litigation. But those type of responses are not uncommon. And that's why we come into court and both sides get to say, Judge, this is why that letter is wrong. This is why I'm entitled to it. Look at this case law. Then the other side says, well, that's wrong because of this exception or because of this. And you need to look at this, Judge. And then after both sides present that, the court makes a decision about what is correct.
All right. I mean, so what are we doing?
Well, again, the reason we came to this is the question of, on March 15th at 3:30, do you want to take up the arguments in your declaratory judgment action, which would include presenting evidence? You referenced some evidence that sounds relevant to me that you want to present. And so is it reasonable to do that on March 15th, or do you need more time to get anything else that you think is prudent? And the reason we had that discussion is I was pointing out that in civil litigation, neither side has a duty in advance unless requested to present their evidence. And that's why parties always request it. They make a request for production. They make a request for interrogatories. However, if you think you already have all the things you'll need, then perhaps you don't need to do that discovery.
Yeah, I don't need
Okay,
I'm good for
that's fine. I just don't want, and you know, it's civil litigation, so I suppose if we get here and for some reason...
issue my subpoenas for Sherry and the court clerk, county clerk, everybody for that hearing, or should I wait?
That would be completely up to you, because I don't know who you want there, because at a civil thing, you're responsible for getting any witnesses there that you want to call in your case that you think are important to make the point of your case.
Well, I would argue where this is a government trying to circumvent the law, that while yes, it should be on me to issue the subpoena, it should also be on them if they don't show up, or if, you know, your county counselor decides that I don't need them, or you guys don't need them, or whatever, you know. I mean, because now you're talking about having a hearing in which several people have lied and probably broken the law and not telling me the procedure in which to go about this. I mean, are there any criminal charges for unknowingly breaking a Kansas statute?
Not as far as I understand with regard to the Cora.
Right. In Oklahoma, there's just if somebody breaks any statute in Oklahoma, they're subject to a misdemeanor. I didn't know if there was something like that in Kansas criminal law or not.
No, I'd say thank God for the citizens of the state that we don't have such a law. I would hate to have prosecutors have access to such a law. I can understand why some private citizens might, but prosecutors have awesome powers already, and I wouldn't want them to have any more.
The powers of immunity are amazing.
Yep, you're right about that. That is true. And those are granted, though, by the legislature and the Constitution, because some of the issues that you are unhappy about have a different remedy. I mean, let's say that you might prevail in this case. I have no idea. I do not know. But the legislature changes the open records law all the time. In fact, they just did last year because people went down there and said this isn't fair, and that was primarily the White case there that happened in Topeka, and the relatives wanted to see this video which depicted Mr. White apparently being shot by law enforcement officers. There was a public outcry over that, and those people went to the legislature. They have the power to change the law, and lo and behold, the people's representatives changed the law to provide relief. So the courts aren't the only place where we have that relief. There's always the ability to use the legislative process to do that. But again, so in civil litigation, whether they're a government entity or a non-government entity, the duties are the same, and they're under no obligation to produce certain witnesses. They're only under an obligation to bring witnesses that they think are helpful to them. And the same with you. You can bring the witnesses you desire that you think are important for you.
But I'm asking, should I subpoena them to that March 15th hearing?
I would submit that if you want certain witnesses there, guaranteed that you need to issue a subpoena to assure their attendance.
Okay.
Because what will happen is, like I said, we'll start at 3:30 or whenever the parties tell me we're ready. If we don't get done, and we have to continue the proceedings to another time to get the rest of your evidence in, that's something that happens in civil litigation. So, all right, we'll set it for March 15th at 3:30 for, I'll call it hearing/trial, because in a deck action, this essentially will be the trial. Again, as I pointed out, there is no right to a trial by jury in a declaratory judgment action.
It will be on the record, though, right?
That you asked for a jury trial?
No, that I am requesting that it be on the record. That's what I'm doing.
Well, any proceeding before myself as district judge is on the record, unlike the magistrate judges whose proceedings generally are not on the record because they're not courts of record. I'm in a court of record as district judge, and so all the proceedings...
So the magistrates are allowed to force people into guilty pleas and stuff and not even be on record? Huh.
Okay, those are two different questions.
Right, I'm sorry. It was just because I know what happened to me in my hearing, and I didn't mean to you don't even have to answer them, Your Honor. My bad.
Well, I guess the answer to one of the questions is, again, those proceedings are not recorded because anything that the magistrates do here is appealable to the district court, and therefore they're really not courts of record. There is recording equipment available, and if arrangements are made and requests are made in advance to have something recorded, sometimes they do that. But in the standard dockets that the magistrates have, nothing's recorded because it's not required to be done. Again, that's the difference with myself as district judge. That's why we really have the recording equipment, so all the stuff that's going on in my courtroom can be recorded. That's particularly true here in Jackson County, where we don't have a court reporter available. The other district judges in our district have a court reporter who would also, or in those counties, they may not record it, and the court reporter is the one that's using either what I'd call a stenography or voice recording to record what's going on in the courtroom. So I don't know about your case. I'm familiar with our magistrate judges. Yes, sir.
KSA 20-302B, section, where'd it go? Section C1 says every action or proceeding before a district magistrate judge regularly, I guess that's where the statute regularly admitted to practice law, huh?
That's right. These are lay judges, the three that we have in the district.
All right, I got it now.
And this, well, it's an issue because they only changed that statute a number of years ago. It used to be the same for all the magistrates, but then there were more and more lawyers who became magistrates, and they thought they'd save some time. And so if it's in front of a law-trained magistrate, then yes, they have to be recorded because those appeals go directly to the Court of Appeals and not to the district court. Whereas if it's from a lay judge, those appeals first go to the district court and then to the Court of Appeals. At least that's the general rule. It gets kind of convoluted at times. Some of the districts have both lay judges and lawyer judges at the magistrate level. We can have an easy rule here in our district in that all our magistrates are lay judges, so at least that complexity doesn't exist. But so that's the reason for that. You are right. That statute referring to law-trained magistrates would have reporting of those proceedings. Okay. I think we're close to the end here. Ms. Morrissey, anything else you need as we look at this deck action and hearing it on March 15th at 3:30?
No, Judge.
So, Mr. Brewer, do you have any other questions or concerns leading up to that hearing?
No. I mean,
Sir, you're cutting out on me a little bit, so
Oh,
if you
no,
just
I
said
don't have
something.
any. No, I don't have any. I'm sorry.
Okay, well, it sounded like maybe you were saying something, and I wanted to make sure I heard you. Okay, so here's what I'm going to do, sir. I'm going to hang up on you because we're going to. Okay, Ms. McKnight, did you find those exhibits?
I did not. I was going to say, can we file that one, and then I have files in my car as well. They might be there, and then I'll run out of my car and bring them back up and file them, or do I have to do them with you?
Well, you'll file them with the district court. That's where this document's going to go. It's going to go to the district court. They're going to scan it in. And so nothing's filed with me.
Okay.
Believe me, you wouldn't want to file something with me.
Okay.
Interestingly, in Nebraska, you do file briefs directly with the district judge. And if you file them with the clerk, you'll get a lecture from the judge like I did many years ago when I was a young attorney. All right, so we're going to take care of that. So, Mr. Brewer, I'm going to hang up on you, and we'll see you in person on March 15th for both these proceedings. We're going to do, what you'll receive is what I'm going to call a notice of trial or notice of hearing. It'll come from the clerk's office. There'll just be a one-sheet piece of paper. I'm not going to do a separate journal entry. Now, Ms. Gerhardt may have done a journal entry on your criminal case, and what she's done is she simply put down the dates. She's noted that you've appeared here by phone. You made a written request to be allowed to do that, and so I was willing to do that, especially since you're representing yourself. And in the past, I believe that you generally appeared in court. Obviously, your filings make that clear that you're very interested in this litigation, both litigations, and you want an opportunity to have the chance for your day in court. And so we want to make sure and provide that for you. I'm speaking about the court system itself when I say we. So I'm going to hang up on you. We're going to get those filed. We're going to get this additional response to the answer filed. And Ms. McKnight, it sounds like if she can find those exhibits today, is just going to bring them up to the clerk's office, and they'll be added to the file. All right?
Sounds good. Thank you. Have a great day, Judge.
All right. You too. Goodbye.